All right, as promised, we're going to go ahead and begin the second session in our Telehealth at the Crossroads conference. We're very pleased to welcome with us today Monica Shimoleski and Kyle Faget to discuss legal and regulatory changes, decisions, and waivers at both the state and federal level. Monica Shimoleski is the partner in healthcare science and healthcare and life sciences lawyer, with Foley and Lardner. She focuses her practice solely in representing healthcare providers, pharmaceutical and medical device companies, and pharmacies in the area of healthcare transactions, clinical research, supply chain, and food and drug law. Monica is co-chair of the firm's life sciences industry team, and she's also vice chair of the firm's healthcare industry team. Kyle is a partner and business lawyer with Foley and Lardner as well. She is a member of the firm's healthcare and life sciences practice group and a core member of the firm's telemedicine industry team. Kyle advises investors, physician practices, and consultants on a range of business, legal, and regulatory issues affecting the telemedicine industry. She handles matters involving contracting fraud and abuse for compliance, Medicare and Medicaid reimbursement, self-disclosures and overpayments, the anti-kickback statutes, physician self-referral or the STAR clause, healthcare marketing rules, HIPAA, corporate compliance programs, contracting, and a range of other issues. We're very pleased to have both of you join us this morning, and there's been many changes, and I expect there will continue to be many more changes. So thank you very much. We're looking forward to hearing your presentation.
Great, thank you so much for having us. So I think the first order of business is figuring out how to share my screen. So I'm gonna work on that. And you tell me on your end if this works for you.
Yes, we can see it.
That's okay, okay. So now let me try and do the next thing. Is this still working?
Yes, yeah, looks okay. Great.
Perfect, awesome. All right, without further ado, always, in the COVID world, you always have to get past all the technical stuff right away. But anyway, so my name is Kyle Faget. As suggested, I'm a partner at Foley and Lardner and a core member of our telemedicine team. General disclaimer, whatever Monica and I talk about today are our opinions and don't necessarily reflect the opinions of our employer, Foley and Lardner. So first thing, agenda. I thought that we would start today by talking about general requirements, that the things you really need to think about when practicing telehealth, really for any provider type and in any state. And then talk about the state telehealth laws, regulations, and standards that will be important for you all to think about when practicing in Louisiana and in Texas. And then, as you all know, there have been a myriad of waivers put in place throughout the course of the public health emergency. And some of those waivers in some states have been rolled back, some are still in force. So we're going to take a minute to talk about the state of waivers in Louisiana and Texas specifically. And then we'll conclude by talking about federal waivers during the COVID-19 PHE. So again, some of those are in place, some of them have sort of changed over time, but importantly, many of the federal waivers have been tied to the continuation of the public health emergency. And if you didn't see already the other day, the PHE was renewed. So many of these waivers will remain valid for the time being, but Monica's going to talk about that a little bit more in a bit. So the first thing to think about when you're thinking about telemedicine, and it's honestly often the barrier to entry for practitioners when thinking about practicing telemedicine, particularly across state lines, is licensing. Physicians and nurses offering care via telemedicine are subject to licensure rules of the state in which the patient is physically located at the time of consult. So if you're licensed in Texas and you're trying to treat a patient in Oklahoma, for example, typically speaking, and that's where the patient is at the time of the consult, you need to have a valid license in the state of Oklahoma. State laws expressly or implicitly require licensure if the patient is located in the state at the time of consult. There are a number of exceptions to this licensure, this basic licensure doctrine, which I'll talk about momentarily. And there are also a number of states, and I'll talk about this as well, that have joined the Interstate Medical Licensure Compact, and there are similar compacts for other licensure types as well that allow for a streamlining of licensure for providers that want to provide services across state lines. So again, general requirements. The physician providing care via telehealth is generally subject to the originating site's state licensure rules. And by originating site, when we talk about originating site, we're talking about where the patient is located when the services are delivered. There are a number of states that offer special purpose licenses and registrations specifically for out-of-state providers who deliver services via telehealth to patients located in the state. So it's like a separate process whereby you don't necessarily have to get full licensure in a state, but rather can go through this other process that is really a special purpose license only for the provision of telehealth services. So as I mentioned, there are a number of exceptions to the basic premise that a clinician needs to be licensed in the state in which a patient is located at the time of consult. There's the peer-to-peer consultation exception. Some states allow providers not licensed in that state to practice medicine via telehealth in a peer-to-peer consultation with a physician licensed in that state. So a lot of times this is like a second opinion or pulling in a clinician who has some specific expertise but is in a different state to help treat a patient. There's also the bordering state exception. So some states permit providers not licensed in that state, but licensed in a bordering state, meaning, a state that's touching upon your state, to provide telehealth services to patients in the state. And really the contours of this bordering state exception are particularly important to know. So sometimes the bordering state exceptions allows clinicians in a bordering state to practice, wholesale, whatever, medicine, but sometimes there are restrictions to what kind of care can be provided when relying on this bordering state exception. So again, it's really important to actually know, if you're relying upon the exception, how that exception actually operates in the state in which you're hoping to practice. So as I said, there is the Interstate Medical Licensure Compact, and there are a number of states that actually belong to it. Again, it's a streamlined way of getting licensed in multiple states relatively quickly. As any clinician knows, getting licensed can take a very long time in states. So, to the extent that that's probably the first place I would look, is to see if a state that I'm interested in practicing in, for example, is a member of one of these compact states. And it's, again, not just for physicians. There's the Nurse Licensure Compact, and there's a compact for PTs. So check first and foremost to see if your licensure type, number one, has a licensure compact, and then number two, if the state in which you're hoping to practice is a member of that compact, because that will definitely make your life a lot easier. Needless to say, however, a lot of times our clients are very interested in practicing in states that are not members of the licensure compacts, like Murphy's Law, but nonetheless, it's good to check. As I said, it offers an expedited pathway to licensure for qualified practitioners. And again, there's multiple types, so it's worth checking. So I just want to pause for a minute and talk about telemedicine state practice standards. And these are basically the 12 sort of key provisions that are really important to think about when considering practicing telehealth. Number one is, what are the state's rules of the road for establishing a physician-patient relationship, or a nurse-patient relationship? It really doesn't matter the licensure type, but there are often very specific ways in which that must occur using the provision of telehealth. Some states, for example, require an in-person exam, that there be an in-person exam before transitioning over to the use of telehealth. We're seeing that go much more by the wayside, but nonetheless, it's important to know if you need to have that in-person exam, meeting that threshold requirement is really important. Whether or not they're originating site restrictions. So meaning that there are, for example, under Medicare, there was in advance of the PHE originating site restrictions, so that patients, to get reimbursed under Medicare, patients could only be located in certain places. Otherwise, Medicare wouldn't reimburse for the service. It's important to know whether the state requires, or the reimbursement mechanism for that matter, requires patient site telepresenter. We're seeing less and less of that, having a telepresenter there, like somebody to who's like an extra person to translate to the patient. Understanding what modality of communication technology is required to have a compliant visit. And the modality piece, again, is really a standard of care issue, but it can vary, as I suggested, according to payer type. So Medicare has its own modality requirements, and then the state boards of medicine often have their own requirements as well. So depending on the payer type that you're dealing with, it's important to know what applies. Remote prescribing. So again, what is required to engage in remote prescribing, including controlled substances. And there's sort of a bifurcated analysis there. One is what's required by DEA to prescribe controlled substances via telemedicine, and then what the state requires. And oftentimes they do diverge. So it's important to know both. And I'll talk about that a little bit more in a minute. Record keeping and record sharing. So sometimes there are unique requirements in telehealth for record keeping and record sharing. Similarly, for informed consent, many states have very specific requirements for informed consent when using telehealth. So again, it's very important to know what those are so that you can get the appropriate consent. And that's really important from a tort liability perspective. So if a patient has not actually consented to or given a valid consent to the practice, and something goes grossly awry, you can imagine that it's very difficult on the practitioner if the informed consent was not valid in the first instance. There's always going to be choice issues along the way. So ensuring that there's actually provider choice, that there's pharmacy choice, and that type of thing. Many states have a number of required disclosures. So, and by that, I mean that there are oftentimes states will say at the beginning of a consult or beginning of establishing a new patient relationship that a provider needs to give their full name, their qualifications, and so on and so forth. So it's a little bit different than if somebody comes in office and, probably nobody really pays attention to the degrees sitting on the wall, but nonetheless, because it's a remote type interaction, there's our states that really want clinicians to provide their qualifications at the outset. There are unique malpractice and professional insurance considerations. So that's an important thing when thinking about if a practice starts utilizing telehealth to ensure that you have the appropriate insurance in place. And then there are credentialing considerations as well, to the extent that credentialing ends up being something you need to think about. There's some unique considerations with respect to telehealth. So those are sort of the 12 big things that we think about when thinking about practicing telehealth for really any licensure type. Not all of these will apply in any given scenario, but in terms of going through a hit list of, do we have all of these things covered? if your practice is considering utilizing telehealth and not necessarily relying on any of the waivers, these are going to be the big things that we would recommend that you think about. So modalities, as I suggested, there are a number of different modalities in telemedicine. And when I say that, what I really mean is there's real-time audio visual. So many states require telehealth to occur via real-time audio video communication. And during the PHE, we saw like a lot of telemedicine occurring via like FaceTime, for example. So that's a real-time audio video communication, not a HIPAA compliant one, but nonetheless, it's just nice, easy example. There's interactive audio with store and forward. That's really kind of exactly what it is. And store and forward, when we're talking about that, we're really talking about email. So interactive audio might be something like you're having a conversation on the phone with a clinician and you send a picture of a wound or something to the clinician who's on the telephone with you. Asynchronous store and forward is just that. So there isn't that interactive audio component, but there's simply the email piece where you might send a photo of a wound and a clinician will look at that and get back to you strictly via email. There's phone only, sort of form-based internet prescribing. Many states have provisions, have laws against sort of internet-based prescribing. We're seeing more phone only since the beginning of the PHE, where you can have an entire visit simply over the telephone. So mental health, we're seeing a lot of that. And by form only internet prescribing, what that's really getting at is being able to go on the internet and answer a series of questions, and a clinician will review the answers to those questions and prescribe based on that, your answers. And again, there are a number of states that have laws specifically prohibiting internet prescribing. However, there are also some ways to build out, so like decision trees, so that it's really an interactive type experience and every patient doesn't end up with the same exact result. So there's actual some real-time clinical decision making that's occurring using AI. So that's something to think about as well. It's a little bit more complicated if you go down that road, but there are several examples of it out in the marketplace currently that are compliant. So another important piece to think about in terms of like state laws is that a lot of times states will have a minimum modality requirement for creating the physician-patient relationship in the first instance. And so, these are just a couple of examples of states, and, please do not take this to the bank because this, may or may not, these laws are constantly shifting. So, make sure that before you decide what's happening in Kentucky, you actually go look or consult with counsel about what's happening in Kentucky to ensure that you have the latest and greatest, most up-to-date information. But as you can see, different states take different approaches to what's the minimum modality required to create the doctor-patient relationship. And then once the doctor-patient relationship is established, a lot of times there'll be, okay, once you do real-time audio visual, then you might be able to go to asynchronous telemedicine, but that initial consultation needs to be real-time audio video, for example. And so again, that varies on a state-by-state basis. Different states have different patient-informed consent requirements. So you can see the state medical boards in some states require a very specific telehealth informed consent. So this is going to be above and beyond the typical consents that you would have a patient sign. And some states don't require it at all. So understanding what that requirement is, again, is really important, particularly from a tort liability perspective. So prescribing, states take different approaches to remote prescribing. Some states have rules specific to controlled substances, and then others have rules that apply to all prescriptions. So remote prescribing across the board. and a lot of states have both. Some states explicitly require an in-person examination or physical examination prior to prescribing, depending on, what some states will deal with this is say you have to have a physical examination prior to prescribing, and depending on what the condition is, that physical examination may be able to occur via telemedicine. So it depends on the standard of care. So there's a lot of nuances in there to think about. Some states permit, like I say, the physical exam to occur via telemedicine, and some are just simply silent on this point. So, when you do have a silent situation, certainly the more conservative approach is to have an in-person physical examination. But again, there's some risk involved if you don't. Some states prohibit remote prescribing based solely on this online questionnaire, as I suggested. And some of this is also regulated through pharmacy laws. So it's important to check pharmacy laws as well to understand the prescribing requirements. Layered on top of this, there are federal laws. So there's the Controlled Substances Act that regulates the manufacture, importation, possession, use, and distribution of controlled substances. There's a DEA registration requirement, and there are prescribing limitations that are important to know about if you are prescribing controlled substances. Importantly, for the purposes of utilizing telehealth to prescribe controlled substances, the Ryan Haight Online Pharmacy Consumer Protection Act of 2008. And basically, right now, what DEA requires, pre-pandemic, and we'll see what happens post-pandemic, is that there be an in-person visit with an individual before prescribing via telemedicine controlled substances. And that's a really tough scenario for providers utilizing telehealth, and particularly for providers that are solely using telehealth. So they have no brick and mortar presence whatsoever. If you don't have any brick and mortar presence, you really can't meet this threshold DEA requirement. But and Monica will talk about this, during the PHE, this was set aside. We're still anticipating that there should be a special registration process under DEA for the provision of telehealth services, but we haven't seen that rolled out yet. So we'll see. But it's important to know the requirement on a federal level is that there be an in-person visit. Some states have taken a different approach, or the medical boards have taken a different approach and said, listen, you know what, for the provision of telehealth, there's no requirement in this state that there be an in-person exam. The hard part about that is whenever there's a state that's in conflict with the federal law, at the end of the day, the federal law still applies. So a clinician relying on the state law to practice still undertakes a certain amount of risk. So important to actually consider that analysis when prescribing controlled substances. So with all of that said, that's sort of the general landscape. I want to take a couple of minutes to talk about the telehealth landscape in Texas specifically. So Texas does have a special purpose license or registration for the provision of telehealth. Texas offers an out-of-state telemedicine license for physicians to practice across state lines. The permitted practice, however, and this is really important, is limited to the interpretation of diagnostic testing and reporting results to a physician fully licensed and located in Texas or for follow-up care. The physician holding a telemedicine license may not practice medicine while physically located in Texas. So, while there is a special purpose telehealth license available, as you can see, it's extraordinarily limited in the state of Texas. There is a peer-to-peer consultation exception. So under the Medical Practices Act, there is a licensure exemption for physicians providing episodic consultations, as well as other consultations to medical schools and other educational institutions. Additionally, the Texas Occupational Code provides that the Medical Practices Act does not apply to a legally qualified physician of another state who is in the state of Texas for a consultation with a physician licensed in the state of Texas, but who does not maintain an office in the state or appoint a place in the state for seeing, examining, or treating a patient. So, I think the take home message here is for the special purpose license, it's extremely limited. And for the peer-to-peer consultation exception, there's some really important nuances to consider if you're relying on that peer-to-peer consultation exception in the state of Texas. There is a bordering state exception that allows physicians licensed in the state with contiguous borders to Texas to order home health or hospice services for a Texas resident to be delivered by a Texas licensed home and community support services agency. So again, there is a bordering state exception, but it's not for the full practice of medicine. It's limited to this home health or hospice services. Other exceptions to out-of-state telemedicine license include the informal consultation performed by an out-of-state physician outside the context of a contractual relationship and on an irregular or infrequent basis with no expectation or exchange of direct or indirect compensation, which is sort of a non-starter for many individuals. And then the furnishing of medical assistance in cases of emergency or disaster, again, if there's no expectation of there's no charge made for that assistance. So that's strictly when a clinician is coming in and offering help in a benevolent way to residents of the state of Texas. There is an explicit licensure exception for follow-up care, only if the physician obtains a special telemedicine license, and there are limitations to an out-of-state telemedicine license. Again, an out-of-state telemedicine license to practice medicine across the state lines is limited exclusively to the interpretation of diagnostic testing and reporting results to a physician fully licensed in the state of Texas, or for the follow-up of patients where the majority of the patient care was rendered in another state and the license holder practices medicine in a manner so as to comply with all other statutes and laws governing the practice of medicine in the state of Texas. Unless a person holds a current full license to practice medicine in the state of Texas, a person holding an out-of-state telemedicine license is not authorized to physically practice medicine in the state of Texas. Importantly, Texas has not joined the Federation of State Medical Boards Interstate Medical Licensure Compact. So there is no abbreviated IMLC way to get licensed in the state of Texas. If you're looking to get licensed in the state of Texas, it's the good old-fashioned long-winded route to getting there. So are there other potentially applicable exceptions in Texas that allow for the practice of medicine across state lines? Yes, for emergencies, and in some instances when the physician is licensed in a border state, as I suggested. So this is sort of just bringing home that point that there's very limited ways in which you can practice across state lines without having full licensure. So back to those sort of 12 core considerations when practicing telehealth, a few of those that are really important to point out: the establishment of a valid physician-patient relationship via telemedicine without an in-person exam. So Texas does allow establishing a physician-patient relationship via telemedicine, provided it meets the standard of care. So of course, you're not necessarily going to be able to establish the physician-patient relationship via telemedicine if what it is that you're trying to treat can't really be treated via telehealth. So that's a clinician judgment call, as well as understanding what the applicable standard of care is. The required modality to establish the physician-patient relationships. In Texas, multiple modalities are accepted, including synchronous audiovisual interaction, asynchronous store and forward technology, or another form of audiovisual telecommunication technology that allows the practitioner to comply with the same standard of care that would apply in person. So that's a lot of time for states. The real requirement is that you are able to meet the standard of care that would apply in person via telehealth. There is no patient site telepresenter required. In terms of controlled substances, the state of Texas may be prescribed without an initial in-person visit. So again, this is this tension that I was talking about earlier, where a state has said, look, you know what, we're okay with utilizing telemedicine to prescribe controlled substances. The clinician that is following Texas state law still operates at a certain amount of risk because the federal law does require that initial in-person visit. That doesn't change just because a state takes a different approach. It just means perhaps the enforcement risk is a little bit lower. The limitation for this, though, is chronic pain. So prescribing controlled substances to treat chronic pain via telehealth is prohibited. Prescribing controlled substances to treat acute pain is allowed unless it's prohibited under federal and state law. So other limitations, as prescribing abortion-inducing drugs, according to the Texas Occupational Code, does not establish a practitioner-patient relationship. Those drugs may not be prescribed via telemedicine. So these are sort of like, the special interest type treating scenarios. But again, it's important to know what they are if you're thinking about practicing telehealth in one of these contexts. So moving away from Texas, there's a few things to consider in the landscape of Louisiana. There is in Louisiana, the board shall issue a telemedicine license to allow the practice of medicine across state lines to an applicant who holds a full and unrestricted license to practice medicine in another state or territory of the United States. So again, Louisiana also has this sort of special purpose license. However, it restricts a physician from opening an office, meeting with patients, and receiving calls from patients in Louisiana. And the physician must establish a bona fide physician-patient relationship. So I think, what that really means is if you have this special purpose license in the state of Louisiana, you can't rely on that if you want to go to Louisiana and open an office in Louisiana. If you want to actually go open an office and practice in Louisiana, you need to have a full license. There is a peer-to-peer consultation exception. So physicians not licensed in Louisiana may provide an informal consultation or a second opinion to a Louisiana physician, provided that the Louisiana physician is personally responsible to the patient for the primary diagnosis, any testing, and any treatment. So it really is just like a second opinion. The primary physician remains responsible for the patient. Except for controlled substance prescribing, there's no initial in-person visit required in Louisiana. There is the limitation, however, that physicians may not use telemedicine for the treatment of non-cancer related chronic or intractable pain or treatment of obesity. You'll see that sometimes that there'll be these states that have a very specific carve out for certain kinds of conditions like obesity, for example. Prescribing controlled substances, unless a physician has had at least one in-person visit with the patient within the last year, not to include physicians licensed in Louisiana who practice telemedicine on patients being treated at a licensed healthcare facility that holds a current DEA registration. So there are facilities that have those DEA registrations, and this is not that. But what you see a difference between Texas and Louisiana is in Texas that in-person visitation is not required, but Louisiana is really mirroring the DEA requirement of having an in-person visit, and very specifically that the in-person visit occur within the past year. So I'm going to pause there and hand this over to Monica. That was a mouthful, and rest assured we are taking questions at the end of this.
Thank you. And now let me just figure out how to share my screen and bring this up. All right. Is everybody able to see this now?
Let me, okay.
Yes, we can see it.
Perfect, thank you. So the background and everything that Kyle provided is important to set the stage to understand what's changed due to COVID, what waivers are out there. And we're going to talk about both federal waivers and state waivers. And I think it's important to note that, as I'm sure you've gleaned from all the great information that Kyle provided, is that the telemedicine is really predominantly regulated at a state level. The federal influence, shall we say, on telemedicine really is regulated by CMS in terms of reimbursement. They have control over telemedicine based upon any of the standards they set from reimbursement. Other than that, largely telemedicine, the modalities, licensure requirements is all state required. So in looking at what is required in the provision of care, COVID, if there's a silver lining to COVID, it might be that it has brought telemedicine to the forefront of everybody's minds of use. We're now seeing providers who normally would never have thought to use telemedicine embrace it. The effects that we're seeing of that is we are seeing increased access to care by individuals. People who normally may not have access to certain services, who might be lost to follow-up, really are now embracing this and receiving additional medical care. So how did we get here? So going back in history, everybody remembers, I'm sure distinctly, January of 2020. It was a year that most people want to forget, but we probably never will. In 2020, the Secretary of the U.S. Department of Health and Services declared a public health emergency. So they declared the PHE. COVID became on everybody's mind. And then following that, in March, President Trump issued a proclamation that COVID constituted a national emergency. So we have now a public health emergency and a declaration of a national emergency. So what did that do? I'm sorry, I'm trying to figure out how to advance these slides here. Here we go. So what happens is when the President of the United States actually declares a major disaster or a national emergency, and the Secretary of the Department of Health and Human Services declares a public health emergency under the Public Health Services Act, then the Secretary is actually authorized to take certain actions and to really use his authority. There we go. And so what does that mean? We have what we call the 1135 waivers. And so under Section 1135 of the Social Security Act, the Secretary of the DHHS has the authority to either waive or modify certain requirements, federal requirements, mind you, under Medicare, Medicaid, and under HIPAA, as necessary to ensure in the emergency situation that there's sufficient healthcare items and services available to meet the needs of all program beneficiaries. So essentially to ensure that anybody who falls under the care of one of these federal programs is able to receive healthcare services and items. So with that, the Secretary declared the PHE. They enacted a number of the 1135 waivers. Congress also passed a number of bills that provided for varying degrees of regulatory and financial relief to healthcare providers during COVID. And the effect of those bills really triggered a cascade of actions that CMS took that were specifically designed to increase access to and use of telehealth services. So those bills really are what triggered, in our mind, what we saw a much more widespread use of telehealth. When these came out, we saw various systems and providers who had never used telehealth all of a sudden put an entire telehealth program in place. Specialists were using it who had never used it before, using it for follow-up visits, continuing care. We were just seeing increased access to it. So that's on the federal side. And again, we're going to talk about some of the specific federal waivers in just a little bit. But as I mentioned, telehealth really is regulated at a state level. So while you have the federal waivers, again, which we'll talk about, what states did in order to waive and provide continued access, increased access to care via telehealth, the states themselves had to initiate their own waivers and put them in place. So what we saw is, to preserve people's access to care during the public health emergency, and consider all the state, stay-at-home orders, et cetera. In Chicago, we were under lockdown for, many months. Several states implemented various waivers to their individual laws. So what was the effect of this? So again, as I mentioned, we saw increased opportunities for out-of-state physicians to come in and provide care to individuals that they normally couldn't. Specifically, we saw an increased access to care by individuals who are in rural areas, in desperate communities, and increased care in relation to diversity as well. And we saw increased types of services that can be delivered by telehealth as well, used beyond what we consider some of the traditional telehealth services. Now, as Kyle mentioned, these waivers, they're in place during the declared emergency, during the public health emergency. As of just the other day, the declaration was extended by the Department of Health and Human Services. And so this is the wording of what the declaration was that was extended, basically saying as a result of the pandemic, the secretary, pursuant to their authority, is hereby, declaring that the public health emergency still exists and that it has existed. So this has been thankfully renewed, and we'll see how long, it gets renewed for. And we'll talk at the end about, there's a question about whether these things are going to stay in place once the public health emergency is no longer in effect, because obviously the waivers are under that. We'll discuss, see a little bit of a crystal ball to see if states are going to take actions to, change some of their laws following the public health emergency. So what are some of the applicable state waivers? What have we seen during COVID that, provides you with greater flexibility in terms of providing care? So Louisiana, the declaration of the public health emergency was extended through July 21st, 2021 today. And unless the governor takes, additional action to extend it, it'll go away. And then the waivers presumably will go away as well. I was trying to do a little bit of digging right before we hopped on this call. I didn't see an extension. If I missed it, my apologies. As I'll mention in Texas in just a minute, that one actually was set to expire today too, but that's been extended. So definitely we'll check and watch to see if Louisiana does extend their waiver, their PHE. They may very well do so. So the waivers that were in effect for Louisiana through today is that out-of-state licensed physicians could apply for an emergency temporary permit to provide care in Louisiana. So certain states would actually enacted waivers that just said if you're licensed in another state, you can just provide services during the emergency. Louisiana is one that said you have to actually apply for a temporary emergency permit. Now it's a lesser standard for licensure. It's a quicker process than the normal, but a physician needed to apply for emergency temporary permit. In relation to that, some of the license requirements, such as submission of fingerprints, training permits, and continuing medical education were waived. Now, the temporary permits were valid for 90 days after the termination of the declared PHE. So in the event that the PHE is not extended in Louisiana, these temporary permits that have been granted to date will stay in effect for another 90 days. Louisiana had certain waivers regarding the prescription of controlled substances. And so Kyle went through the various requirements, for issuing prescriptions of controlled substances via telemedicine. During the COVID pandemic, the requirement of initial in-person visit prior to recommending medical marijuana was waived. Now, remember though, this is still subject to federal law because you have the federal law regulating the prescription of controlled substances. But then also there was a waiver of an in-person initial visit and in-person visits even after, the prescription and controlled substances for chronic pain. There was that waiver as well. So those were the waivers that we saw in Louisiana. Remember that, but for those waivers, all of the other requirements that Kyle talked about for practicing telemedicine in Louisiana are still in place and still need to be complied with. So Texas, as I mentioned, their declaration was also set to expire today, but it was extended for an additional 90 days. And so we'll keep watching to see if there's continued extension. Again, it's up to each state to determine what they want to do, if they're going to continue with their waivers, if they're going to, extend their declaration, or if they're going to let them lapse and expire. Once and if they lapse and expire, you need to, except for like Louisiana where they have a 90-day past, for the licensure, you need to make sure that your services, your programs are compliant with the applicable state laws for telemedicine, all the state practice laws, licensure laws, etc. So Texas had a number of waivers during the COVID PHE, still in place, as I've mentioned. The first one, like Louisiana, out-of-state licensed physicians can apply for an emergency visiting practitioner temporary permit. Again, you actually have to apply. It's just not automatic. These permits are going to continue to remain valid for 30 days after the declaration expires. So a little bit of a shorter time period than Louisiana. I will mention that I've worked with various clients who are in the process of expanding telemedicine programs, sending up new ones, and have considered the licensure. What are their requirements going to be? And the one thing that I have counseled people on and continuing to recommend is structure your programs for compliance without the waivers, because we're not sure what's going to happen after these waivers go away. They're really designed for increased care during the pandemic. So additional waivers in Texas that, and again, I've underlined that during the disaster declaration. I mean, I just can't stress this enough. These are all in place during the public health emergency. So physicians can establish a physician-patient relationship, for encounters, without an in-person visit, for encounters, which include the diagnosis, treatment, ordering of tests, and prescribing. They can, in terms of controlled substance waivers, they can, issue, or refill to an established prescription with a patient for a chronic pain patient for controlled substances via telehealth. The caveat to that is the physician must have within the last 90 days actually seen the person in person or via an audio-visual telehealth. So you couldn't use the modality where you're just talking on the phone. You actually needed to see like an audio-visual. And then again, there's various documentation requirements. And then physicians could also issue prescriptions for controlled substances for acute pain via telehealth. Again, always remember these are all subject to federal laws. So on the federal side, those are the telehealth Texas waivers. So I mentioned that there are federal waivers that apply as well. So similar to Texas and Louisiana and various other state governments, the federal government issued several waivers of the federal statutory requirements during the PE. Most of these waivers, if not all, essentially have expanded access to telehealth services. And again, mentioned that it's the declaration was extended here. So before I go into the waivers, I'm going to just briefly mention what was in effect pre-COVID so that you understand what the waivers do. And again, as I mentioned, this is really the federal side. We're really looking at Medicare. What are their requirements for reimbursement and conditions? So really quickly, because I'm being conscious of time, there were, to receive reimbursement, the patient had to be in a qualifying rural area, at qualifying facilities, services had to be provided by an eligible professional. The technology needed to be real-time audio-visual, and it had to fall within different procedure codes. So really what's limiting about that in terms of access to care is that the originating site is essentially that's where the patient is. So if I'm here in Chicago, Chicago is the originating site. And the patient needed to be in a county outside a metropolitan statistical area, either in a rural health professional shortage area in a rural census tract. And essentially the Health Resources and Services Administration decides what those areas are. Now, not only did you have to be in a rural area, but the patient actually has to be in an originating site as well in order to qualify for reimbursement. Now, originating sites they're limited because it's physician offices, hospitals, rural health clinics, skilled nursing facilities. So think a facility where the patient is actually going to have to physically travel and go to one of these facilities to actually receive the care. That makes it limiting in terms of receiving health services via telehealth. Eligible practitioners are what you would normally think: physicians, PAs, NPs, clinical nurse specialists, clinical psychologists, etc. Those are the individuals that would have to provide the services. And so then this is another factor of reimbursement, is that the service had to be provided, as I mentioned, using interactive audio that permits real-time communication between the physician and the patient. You could not use asynchronous technology. Now, Medicare, did a great job, in my opinion, during COVID in providing, these waivers and lessening the requirements so that it really increased access to care by individuals throughout the pandemic. And it really, part of it was also designed to keep people safe, allow people to be in their homes so they can receive care, not have to travel to hospitals if they don't need to, try to reduce exposure. And, they really had a lot of those effects. So Medicare expanded originating sites. So as I mentioned, they now, during the pandemic, patients are allowed to receive telehealth services in their homes. So you don't have to leave your home and you can still qualify for telehealth services. They increased the provider types, the people that can provide the services. For example, now physical therapists and occupational therapists are considered to be providers for telehealth services. And they also significantly expanded the list of codes for reimbursement. So now more services are subject to reimbursement. They expanded the Medicare requirements for licensure. So they essentially waive Medicare and Medicaid requirements that the physicians and nurse practitioners have to be licensed in the state where they provide the services. So, if you're a, Louisiana physician and you're providing services in Texas, or to receive reimbursement, you would have had to be licensed in Texas. Medicare waived that if, the provider is enrolled in Medicare, if the provider possesses a valid license, in the state of his or her residence, when the provider who furnishes the services, whether in person or via telehealth, is in the state in which there's a public health emergency, and they haven't been excluded. They also, now I will say, so Medicare released, they lessened their licensure requirements, but you still have the state licensure requirements. So you need to make sure that you actually still are complying with the applicable state licensure requirements and or their waivers. And then they relaxed the enforcement that a patient has to have a prior relationship with the person prior to furnishing telehealth. They increased patient parity. So during, prior to the PHE, services were often reimbursed at a lower rate than in person, but there's now payment parity during the pandemic. And then the OIG actually released enforcement against providers who reduce or provide waivers of co-pays or sharing of fees. And then waived limitations on the frequency upon which certain services can be provided by telehealth. And so again, a lot of this relates to reimbursement. And then Medicare also, CMS basically waived the requirement of the audiovisual functionality in use of prohibition on use of telephone services in certain circumstances. And sorry, I'm flying through because we're at the end here. And finally, Kyle mentioned, when we were talking about certain platforms not being HIPAA compliant, for example, when you're providing these services, you're still subject to HIPAA and you need to be compliant with all the HIPAA laws. the Office of Civil Rights has actually relaxed some of those requirements for use of compliant non-public facing communications, so Facebook or Zoom. But think about what is not considered to be a non-public facing communication. Facebook Live, TikTok, things like that. You should never use those to provide services, but you're allowed to now use things like Facebook, Zoom, things that you normally, or Skype, that you would normally not see in providing services. So I've been flying through this, and I know we want to, if there's any questions, but the key, as we mentioned, we've kind of been hitting over the head, waivers are in place during the public health emergency. So be conscious of the fact that once the states retract their waivers, when the public health emergency is no longer in place, minus a few carryover, you're going to need to comply with all the regs that Kyle had mentioned in the beginning. States may take actions at Medicare to make things permanent in terms of what, some of the waivers, the changes, and it would be wonderful. But we recommend that when you're looking at things, that to the extent possible, consider compliance with, the current, the state of regulations pre-COVID. So that is it. Let me stop sharing my screen. And I know we are right at time there, so I apologize. Kyle and I, of course, are available for questions via email, telephone calls. I answered one in the chat I saw during the presentation about Texas and the compact, where it is correct, Texas, I did see passed enacted legislation to adopt it, but it hasn't been enacted yet to my knowledge. And so that will become, once it's enacted, the compact will be available to Texas. And so with that,
Kyle, Monica, thank you both for those presentations. They were excellent. And you preempted my
uh-oh, Cameron, I think we froze for a moment here.
Uh-oh.
No.
We lost you, Cameron.
to effect September 1.
There we go. I think you're unfrozen.
How about now?
Perfect. We
Yeah.
can hear you. That's good. Welcome to technology, right?
I know.
Hopefully
what
the
were-
telehealth visits go much more smooth.
Exactly.
Perfect. So you actually, Dr. Santos, would you please moderate Q&A since I seem to be having some connect?
Sorry about that. We just have a a little bit of a technical difficulties. I think Monica and Kyle, did you answer Dr. Phillips' question regarding the compact? I think the Texas legislation. Okay.
We did.
Yes, it was passed. It, to our knowledge, it has not yet been enacted, but once it is enacted, it will be available for use in the state of Texas.
Okay, how do you think that will impact, especially in the border areas? We have neighboring areas like Oklahoma, Louisiana, New Mexico, especially us. We are taking care of a lot of New Mexicans, in our area. How do you think this will affect our practice?
So good question. I think what will happen, to the extent that there are clinicians that want to practice in the state of Texas but are not located in the state of Texas, the path to full licensure will be much easier once Texas actually enacts and joins the Interstate Medical Licensure Compact. So how will it impact things? Well, chances are you will see more providers offering telehealth services at full scale in the state of Texas than what you see right now. Yeah, go ahead.
Yeah, sorry, I didn't speak over you. And conversely as well, I think it will provide increased opportunity for the Texas licensed providers to then obtain licensure in the bordering states if they participate in the compact, to be able to expand your offerings to patients, say in New Mexico or in any of the bordering states as well. So I think it'll be an increased opportunity for Texas providers as well to reach patients in other states.
Does it need a agreement between our border state as well, like Oklahoma, so it will be reciprocal?
Right. So to take advantage of the Interstate Medical Licensure Compact in Oklahoma, Oklahoma would have to be a member of the Interstate Medical Licensure Compact.
Right. But it will not take an agreement like between an individual practice in the state. Is really once the state is participating and the physicians utilize the compact, they're able to access the licensure requirements of any state that's also participating in the compact.
Do you
They
happen
do
to
have to go
know
through the
if
process.
Mhm. Do you
But
happen to know if Louisiana, Arkansas, New Mexico, and Oklahoma are part of the compact as well? So pardon my ignorance.
No,
No,
that's totally
good
fine.
question. It's ever changed. Kyle, do you have that at your fingertips?
Yeah, I'm looking at it right now.
I know, because we
Uh,
monitor the states that actually participate in the compact, and then oftentimes it's, legislation's been introduced or it's been passed, but it's not yet, enacted. And so it's constantly changing. So we're just checking really quickly.
Yeah,
All right.
so it looks like, yes, it looks like Oklahoma has it's a member state. But there's some issues there, so it's worth actually confirming. And Louisiana does look like it's a member.
All
So,
right.
yeah.
Perfect. Thank you very much. And there is another question here in the chat box from Virginia Carden. Paramedics stabilize patients, do EKGs, vital signs, and perform CLIA wave test.
Yeah.
What is needed to them to be approved as telemedicine provider or telemedicine presenter?
Okay, hold on, let me look at this one more time. So paramedics stabilize patients, yep, do EKGs, vital signs, and perform CLIA wave tests. Yep.
Mhm.
What is needed to have them as approved telemedicine? So, good question. I think some of it depends on the licensure board. For paramedics, that's really what's going to dictate what is allowed for telemedicine for paramedics. The telepresenter, that's, again, it doesn't look like any of the states have that requirement, at least not Texas. So I wouldn't even worry about that piece, but I would look to the licensure board to see what the requirements are for the provision of telehealth for paramedics.
And Virginia, I just like to plug that Texas Tech have a FIT lab, Frontiers in Technology Laboratory, that gives a certification and appropriate training and education in case you're interested.
Okay. And I know you didn't ask this, but just Dr. Santos, so you know, New Mexico is not a member of the IMLC.
It's
Sorry.
always a problem.
Yeah, right. Like I said, it's always the case that the state you want to be a member is not a member. So, nor is Arkansas. So just two things to know. It looks like Louisiana is and Oklahoma is on the path to being a member.
Well, I'm still hoping and, positively optimistic that things will get better moving forward.
Yes. It looks like Billy Phillips. Do you think there is any merit to a unified licensing board for all health professionals? Do you know of any states where that is done? Sure. Yes, absolutely. I think there's a lot of merit to it. So there's kind of two ways I think to think about this. One is a unified licensing board for each provider type. So a unified licensing board for physicians across the United States. So not within a state, but across the United States. And then, as you've suggested, maybe for all healthcare provider types, there be one licensure board. So instead of there being the medical board and, a licensure board for nurses or something like that. Yes, absolutely. I think there are a couple of issues there. One, I think that having one licensure board for all provider types could be complicated because there's scope of practice issues. So that licensure board would really have to be represented by every single licensure type. It would be a big undertaking for that particular licensure board. I think that having a single, so let's say a physician licensure board across the United States, I think that's what the Interstate Medical Licensure Compact is trying to get to at some level. I think, though, that for good or for bad, there's a lot of resistance to that, in part because states like to have control over who's practicing in their state and understand who's practicing in their state. And medical boards can be pretty protectionist. And I think until that changes, and there's this concept that like the standard of care, for example, is somehow different in like California than it is in like North Dakota. And, you know, treating a cold, hopefully in California isn't that different than in North Dakota, but nonetheless, like there is a thought that the standard of care can vary across geographies. And maybe that's true and maybe it's not, but I think those are the kind of like philosophical issues that have to be grappled with and resolved before you could have, let's say, for example, a single US physician licensure board or a single US like nurse licensure board. It'd be great to see. I don't know that I see it happening though. I don't know, Monica, do you disagree?
No, I don't disagree. I think one potential avenue to facilitate something like that, I think it would act more like the compact in a way where you could have one main licensing board that sets forth certain, you know, standards requirements for licensure, but I could see each state then having their own subset of that, where, you know, they can rely on the main licensing board for certain things, but if they, because really it's up to each state to regulate their professionals, you know, and have their own, you know, standards of practice requirements. So I could see each state, you know, perhaps saying, okay, you've met, you know, the threshold, but now here's our specific state requirements for licensure as well. That might be a way. So it'd be a little bit perhaps more of an expedited path. But I think it's going to be a challenge. I do, to try and get all the states to agree on something and do that. It would, it'd be great, but I think it's going to be a bit of a challenge.
Yeah.
Kyle and Monica, I think there's another question from Brian Taylor in the chat box. Are there plans to evaluate telehealth by provider type and relevant licensure boards?
I'm trying to see if I can see it.
Oh, you said in the chat box, not in the Q&A. I'm sorry. Are there plans to evaluate? So evaluate by provider type and relevant plans to evaluate. I am not quite sure by, you know, who you're speaking of, but I am not aware of, you know, of any of the licensure boards saying we are going to evaluate, you know, the provision of telehealth based upon, you know, who the provider is, you know, what the type is. I think that it would be beneficial, you know, for states as they're looking at their standards of practice and, you know, the laws for telemedicine to consider that and to hopefully broaden it, you know, the ability, you know, of providers to provide by, you know, services via telemedicine, but I'm not aware personally of any.
Fair enough.
I think there's a last question from Dr. Phillips. With more and more interprofessional practice and such overlap of knowledge in some health profession, do you think the scope of practice strictures will lessen over time?
Go ahead, Monica, if you want to, sure.
I think the scope of practice may broaden over time, but I think there's still going to be state laws that actually define what the scope of practice is for each type of clinician, for each practitioner that you have to adhere to. You're absolutely right. I mean, we are seeing, you know, more overlap in the professions, you know, people able to perform services that are overlaps, but I do still think I will be surprised if there comes a day where the scope of practice requirements are lessened. I just think you'll see broader scopes of practice, in my personal opinion.
I think that's right. I still think there's always going to be some demarcation there, though. So, for example, if for no other reason, there's also economic incentives to think about, right? So if you can do everything that a doctor can do as a nurse, then why go to medical school, right? So there's still
some training. Yeah, I mean, is the training that, you know, these individuals are receiving such that they should broaden the scope of practice? You know, it's, you know, what are they training on?
Right. But I do think that you'll see more and more of and more practices utilizing like collaboration agreements and that kind of thing. But I also think as you see more oversight, like physician oversight, for example, of nurse practitioners or the like, states are going to double down on ratio requirements. So there are a lot of states that have a ratio requirement. So a physician can only enter into X number of collaboration agreements and have oversight other licensure types, a certain number of them. And that makes sense, right? Because at some point, are you really having meaningful oversight? And if the idea is that the buck is going to ultimately stop with the physician, then I think you do have to think through those issues pretty carefully.
All right, thank you very much. I knew we went over time, but this is a very exciting and informative, topic. And Kyle and Monica are repeat speakers, and we would like to invite them again for next year for sure, to get updates regarding regulations. So consider this an
Yeah.
invite.
Invitation accepted. We really love this stuff. And if anybody listening has some follow-up questions, feel free to reach out to either one of us. We love talking about this stuff, and we'd be more than happy to engage in additional dialogue.
Oh, absolutely.
Again, thank you very much, Kyle and Monica. We really appreciate your presence here.
Of course. Have a good day, everybody.
Take care.
All right. Bye-bye.